Welcome to this third webinar in a series of 4 on racism and discrimination organized by the focus area on migration and societal change here at Utrecht University. My name is Ilse van Liemt and I'm an associate professor in urban geography. I'm one of the 4 research leaders of the focus area on migration, together with Professor Marcel Lubbers from the Faculty of Social Science, Professor Barbara Omen from the Faculty of Law and Governance, and Professor Christoph Baumgartner from the Humanities Faculty. We are running the focus area on migration and societal change. This focus area provides a platform for researchers here at Utrecht University working on migration and related societal transformations. The focus area stimulates collaborations between researchers from different disciplines, but also with stakeholders in the wider society, and particularly with stakeholders here in Utrecht. We believe that it is the combination of disciplinary perspectives and the close cooperation with societal partners that can lead to new important insights that are useful for addressing societal challenges in the field of migration. And in this series, we want to discuss the major trends concerning racism and discrimination. Racism and discrimination in our streets, but also in our institutions. And the various forms of inequality that is causing and the effects it is having on the quality of life and social cohesion in our cities. And with this series, we hope to better understand what is going on, but also to discuss opportunities for change. So we have discussed discrimination at the labor market in an earlier webinar. We've also looked at the housing market. And if you've missed these seminars, you can still watch them back online. Today, we are going to focus on discrimination and exclusion from a human rights perspective. So we're not taking a field, but we take a perspective, or maybe the legal field, as our focus of attention. And in order to explore this issue from a legal perspective, we have invited 2 experts. 3 speakers were announced, but unfortunately Mariam Chepti, member of the Netherlands Institute for Human Rights, het College voor de Rechten van de Mens, is ill today, so she couldn't join us, unfortunately. We will still try to get some of the real-life illustrations in the discussion with the 2 experts that are here with us today in the studio. So our first speaker is Alexandra Timmer. She's an associate professor human rights law at the Netherlands Institute of Human Rights here at Utrecht University. And Alexandra's research focuses on equality and non-discrimination, in particular in EU law and international human rights treaties. She has a special interest in gender and law, and she has published really widely on the topic of discrimination and equality from a human rights perspective. Alexandra will help us to get an overview of where we stand in relation to international human rights treaties and EU law when it comes to discrimination. It's not an easy task, so I've asked you to give a state of the art. Where are we at this moment? I'm very happy you're here with us in the studio today. Can I give you the floor?
Thank you, Ilse. Yes, thank you for this kind introduction and for the kind invitation, of course, to speak at this webinar and to interact with the focus area. So yes, I'm here with the enviable task of giving you a state of the art regarding non-discrimination in human rights law. And perhaps a few introductory comments are first in order. First, equality and non-discrimination have a dual character when it comes to human rights law. What I mean with that is that in the first place, they are a right in themselves. In all major UN human rights treaties and also regional human rights treaties from the Americas, from Africa, from Europe, there are provisions on non-discrimination and equality before the law. So equality and the prohibition of non-discrimination is a human right in itself. But there are also underlying principles underlying the whole human rights architecture as such. The idea of human rights is that all humans inherently have rights as human beings. So underlying that idea of universality, all humans have human rights, is also an idea of equality. Now today I will speak more about sort of the first rule, namely equality and non-discrimination as human rights in themselves. And I was preparing for this mini lecture and thinking, okay, the bird's eye view, what is the bird's eye view? And I came to the following. I think if we really take several steps back, then non-discrimination is both widening and deepening. What do I mean by that? And then I'm sort of taking a sort of historical perspective here, legal perspective. So the human rights architecture, the legal architecture of human rights law as we know it today was devised after the Second World War. We have the European Convention on Human Rights, which dates from 1950. We have the Universal Declaration of Human Rights really at the global level, which dates from 1948. And from then onwards, more human rights treaties were adopted. Regionally again, in Europe, in the Americas, in Africa, and at the global level. So we have now these treaties for more or less 75 years. They are the oldest. And in this time, when it comes to non-discrimination, the provisions on non-discrimination and the reach of the principle of non-discrimination has widened in the sense that more and more grounds have been recognized under non-discrimination law. So whereas in 1950, 1948, the focus was more on well, on several things, but there was, of course, after World War II, there was a discussion about ethnicity, about language, about religion, obviously. Sex was already included as a prohibited ground of discrimination. But in the past, the more recent decades, we've seen also discrimination on the grounds of disability, on the grounds of sexual orientation, on the grounds of gender identity, being prohibited. So in that sense, the application of the principle has widened. I think it has also deepened in the sense that over time, both civil society but also the treaty bodies and the international courts have come more to the realization that a purely formal conception of equality is not enough. So it has deepened in the sense of deeper unpacking this notion of equality. Now, I don't mean to present this as a pure sort of linear progress story, where we're ever widening, ever deepening, and Hosanna. It's not as simple as that. Equality and non-discrimination are deeply contested concepts, as I always tell my students. And well, actually today I wish to talk a little bit about those concepts. So the three things I have on the agenda for today is first the conception of equality, or rather conceptions, plural, of equality inherent or visible at least in human rights law. Then I want to move on to different forms of discrimination that are legally recognized as such. And third, I want to finish with the challenges. So let me first start with conceptions of equality. And for that, I use the CEDAW Committee's work. The CEDAW Committee is, the CEDAW Convention is the Women's Rights Convention of the United Nations. That convention was adopted in 1978. So it's, middle-aged by now. But the interpretation of the committee is very much fresh, I would say. And it gives you, I think it's a good introduction to the ways in which equality has been conceptualized within human rights law. And I've put it on the slide. So in one of its general recommendations, that's one of the documents of the committee. The committee has clarified that equality actually consists of 3 layers. And I would refer to these as formal equality, substantive equality, and most deeply and most radically transformative equality. So what is formal equality? Usually formal equality by lawyers is defined as treating likes alike. The CEDAW committee gives it a little bit of a different twist. Oh, and I should say, and I apologize that this is, it's in Dutch still, the title, but these 3 conceptions of equality have formal, substantive, transformative. They correspond to 3 central state obligations that states have under the convention. And perhaps I should also tell you that almost all states in the world have ratified this CEDAW convention. A notable absent is the United States of America, but I forgot what the exact number is by now, but more or less 190 states around the world have ratified the convention. So these are the core obligations that states have under this convention. And in the first place, the committee says the states should ensure that there is no direct or indirect gender discrimination. Secondly, so to ensure that there's no discrimination, and I'll come back to what that means, direct and indirect, later on. But that's only the beginning. Secondly, states should also improve the de facto position of women, but I would put that more broadly, to improve the de facto position of disadvantaged groups by means of positive action. So to take actions proactively, to take measures to improve the position of disadvantaged groups. Famously, this can take the form of quotas, but you can think of a whole range of actions. And then thirdly, and this is the layer that I find most interesting, but it's also the deepest layer, let's say, of inequality that is most difficult to tackle. The committee has said that states are under the obligation to address prevailing gender relations and the persistence of gender-based stereotypes. And okay, this convention is specifically is the Women's Rights Convention, but I think you can pull this broader beyond gender. I think this is actually a pretty good summary of formal, substantive, and transformative equality. It is about ensuring that there's no discrimination, improving the de facto position of disadvantaged groups, and thirdly, to address prevailing social and cultural relations that often manifest themselves in the form of stereotypes, not just gender-based stereotypes, but also racial stereotypes and intersectional stereotypes. Now, let me move to then the forms of discrimination. So, actually, the CEDAW committee, but also other UN human rights treaty bodies and human rights courts legally recognize different forms of discrimination. And the most commonly legally recognized forms, or the most basic, are both direct and indirect discrimination. So direct discrimination is when a difference in treatment occurs on a prohibited ground. Think racial segregation in the US in the pre-civil rights era, where very bluntly there were signs saying blacks not allowed. That's clearly, that's direct discrimination. Indirect discrimination is a bit more complex. That occurs when a facially neutral criterion in practice has a disproportionate effect on a protected group. Now, perhaps a bit of a silly example, but it does get, you can grasp the content, is our height requirements. So there are several cases, for example, from the EU Court of Justice on height requirements to enter the police force from Greece, for example. Greece had a height requirement of 1.70 meters high for people in order to apply to become a police officer. The effect of this was that many more men could apply than women, because men are statistically taller than women. So while this appeared neutral, a height requirement of 1.70 meters, in effect, it was held to court indirect discrimination on the basis of sex. So that's direct and indirect discrimination, but actually the law also recognizes harassment as a form of discrimination. Harassment occurs, and perhaps we all have an idea, more or less, what, especially after Me Too, we have an idea of what harassment means, but legally it means unwanted conduct that violates the dignity of a person, and this can occur on the street harassment, but it can also occur, for example, at the workplace or at school. So harassment is actually legally recognized as a form of discrimination. Now, potentially there are any numbers of forms of discrimination. I just listed some of the main ones. So we have direct, indirect, harassment. Denial of reasonable accommodation is also one that I just want to mention. It comes specifically from disability discrimination. And it occurs when people with disability are denied what we call a reasonable accommodation, even though that accommodation wouldn't come at too high a cost to an employer, for example. Then intersectional discrimination, and perhaps we'll come back to that later on in this webinar. But intersectional discrimination is something that came from, as an idea, as a concept, came from scholars and came from activists. And it is the realization that discrimination doesn't occur only on one ground, but that discrimination often, if not always, occurs on a complex or an intersection of grounds, for example, gender and race. So people are not only affected by sexism, but they are affected by sexism and racism, or sexism, racism and classism, or ableism or ageism. And of course, we all have not only a sex, a race, a sexual orientation, etc. But the point about intersectionality is not to look at the individual, but the idea behind this was to look at the more structural factors affecting people. And the critique was that discrimination law, and this critique I think still stands, is very much focused on a single ground approach. So discrimination law, and for that reason also we see judges struggling with this concept of intersectionality, even though conceptually they might be sympathetic towards it, at least some judges, but legally it's quite difficult to translate, because still the law is based on this idea of, okay, you suffer either sex discrimination or race discrimination or age discrimination, etc. And that brings me to structural discrimination. More and more people are talking about structural discrimination, although I have to admit those people are not, in the first place, I would say lawyers, or let me rephrase that. I think lawyers are not in the vanguard of tackling structural discrimination per se. In fact, if you try to look at, okay, what is actually structural discrimination from a legal perspective, what would the definition be? It doesn't abound definitions out there. For example, the EU Court of Justice or the European Court of Human Rights have never talked about structural discrimination, let alone give a definition of it. There is a definition that I found rather good from the Inter-American Commission on Human Rights, and it's on the slide there. I'm not going to read the whole thing out loud, but the point there is that structural discrimination gives rise to a situation of inferiority and exclusion against a group of persons in a generalized sense. So it's not something that is just an individual incident. No, structural discrimination occurs broadly, and the Inter-American Commission also emphasizes over time. So it occurs through the over time and generations. And the Commission, Inter-American Commission, emphasizes the large scale nature of the problem of structural discrimination, and also admits that it doesn't lend itself well to a very strict or narrow definition. And that again makes it difficult to tackle legally, because lawyers like definitions because we want to know whether a certain legal provision applies. Now, so to sort of cap this point on forms of discrimination, I think direct and indirect discrimination are the legal basis, and from there onwards, new concepts such as harassment, such as denial of reasonable accommodation have been developed. I think the most cutting-edge concepts in a way are intersectional discrimination and structural discrimination, but these are also precisely the ones that are most difficult to translate legally. Now, I think that provides me with a nice segue into the challenges, the final part of this mini presentation. Okay, again, very broad questions, but what are some? I don't pretend to be exhaustive here, but what are some of the main challenges facing, well, at least non-discrimination lawyers or human rights lawyers who want to move forward with the project of non-discrimination? Well, first I wanted to mention backlash. And this is more of a political problem than perhaps a legal problem, but it's a political problem that has legal effects and legal implications. So resistance against the idea of equality and non-discrimination. We see it very clearly now crystallizing backlash against gender equality. So, for example, a decade ago, the Istanbul Convention was adopted. The Istanbul Convention concerns and prohibits violence against women and domestic violence. It was called the Istanbul Convention because it was ratified in Istanbul, but Turkey itself now has withdrawn from the convention just some months ago in 2021. And Turkey is not the only country where there is backlash against gender equality. We see that happening in Poland, we see it happening in Bulgaria, Hungary, but also here in the Netherlands, even though, the Netherlands has not withdrawn from the convention, and I don't think that will happen anytime soon, but there is political resistance to the idea of gender equality, and particularly there's resistance to the idea of that third deepest level of equality, of transformative equality, and of combating stereotypes. So that is one challenge, the backlash. And I don't think we shouldn't take anything for granted here. It's not, and again, I also said it at the beginning, human rights and non-discrimination are not a linear progress story. It's a bit 2 steps backward, 2 steps forward, 1 step backward, or even, going in all directions. And there remains a lot of contestation. Second challenge I wanted to just briefly touch upon is the conceptual one, or conceptual ones. As I already mentioned, it's difficult to get at the structural forms of discrimination. And several concepts, legal concepts, have been developed by scholars and have been adopted also by UN treaty bodies or even by courts to try to get there at that structural level of the sort of widespread racist, gender, etc. discrimination. Stereotyping has been one of them. Intersectionality has been another concept that has quite, transformative potential, but what we see is that these sort of hit a glass ceiling. And then they were developed with very good intentions, but the law keeps resistant to change, and that perhaps brings me to my third and last challenge. And that is, and this is more of a critical legal theory point, but law in itself is gendered. is raised. And it is very difficult, even though there are provisions that proclaim that discrimination is prohibited. Racist, gender stereotypes are everywhere in society, also in the law itself, also in law enforcement personnel. So, critical scholars remind us, and this is a famous quote from Audre Lorde, a black feminist scholar, that it's doubtful whether the master's tools can ever dismantle the master's house. So in a way, law has been developed to maintain a certain status quo, to arrange a status quo, and to what extent can you use law to change that very status quo remains always a difficult but very interesting and worthwhile project. Thank you.
Wow, thank you so much, Alexandra, for giving this overview of the field, the widening, the deepening, but also the complexity in the field and how the field itself has changed over time. I think you addressed many important challenges, maybe not all of them, but many important challenges that we're going to also talk a little bit more about later on. I want to introduce to you the next speaker, Lisene Delgado. And Lisene defended her PhD research here at Utrecht University last December. And her PhD is called Being Human and Having Rights. She's currently assistant professor at Tilburg University. And her research focuses on human rights education. And for her PhD, she looked at the UN and Curaçao as two case studies. I think it's very interesting follow-up to now talk about education as well, because we've discussed the law as a framework, but when we talk about education, it's also about implementation of the law in a very specific form. I'm really excited to hear more about your work, and the floor is yours.
Thank you. Thank you for this introduction, and I also really like, Dr. Timmer, that you just mentioned that law is raised. I would say that human rights law too is raised, and I will touch upon that in this presentation. So I'm going to talk about human rights education, more specifically in the context of the Kingdom of the Netherlands, and it is with a reason that I say the Kingdom of the Netherlands instead of the Netherlands, in relation to racial discrimination. So for my dissertation, I conducted research on human rights education. I examined human rights education as formed by the United Nations. And I also researched human rights education in Curaçao, more specifically human rights education in secondary schools. I had the privilege to work at the University of Curaçao and also at a number of universities here in the Netherlands whilst I was doing that research, and I taught constitutional law. This is important for what I'm going to discuss in a couple of minutes. Because what I want to discuss today is one of my most remarkable findings, I think, and that is that human rights are something else in the Netherlands than it is in Curaçao. And related to this is that human rights education in the Netherlands is something different from human rights education in Curaçao. I'm not talking about human rights in general, because I find that human rights means something different to me than it means for someone else. Today I'm talking about human rights law, and with this I mean human rights as institutionalized through codification in law and also further interpretation, most notably by the legislator, also courts, legal scholars, etc. So as I started saying, human rights in Curaçao are something different from human rights in the Netherlands. And I'm painfully aware that for many it's not instantly clear what Curaçao has to do with the Netherlands. So this in itself is already remarkable. But in short, the Kingdom of the Netherlands consists of 4 countries: Aruba, Curaçao, Sint Maarten, and the Netherlands. And the Netherlands then also includes Bonaire, Sint Eustatius, and Saba. Or, depending on your interpretation, you could also say that the Netherlands is a colonial state with a number of colonies in the Caribbean. So, to further touch upon the difference between the understanding of human rights in Curaçao and Netherlands, just in general, I can walk around in Curaçao and ask any random person in the streets about the relation between Curaçao and the Netherlands, and they will have something sensible to say about it, and maybe even mention the Charter of the Kingdom of the Netherlands. I will come back to what the Charter is. And as I also found is that pupils in secondary schools are taught about the past and current legal relation between the 2 countries. In contrast, in the Netherlands, it is possible to graduate cum laude in constitutional law and not be able to explain this legal relation as I did. Just as now, during my teaching experiences in the Netherlands, the Caribbean is not mentioned at all or only as a sort of a footnote. I normally try to stay away from comparing, but the differences I just mentioned are not innocent. They are grounded in the legacies of colonialism and racism, and they are grounded in unjustifiable legal differences that I would categorize as institutionalized racism. These differences are related to a phrase that I found in educational material in secondary schools in Curaçao. And the phrase was, quote, "People in Curaçao have the Dutch nationality. This means that abroad, Curaçaoans are treated equally to other Dutch people." Imagine that. Being taught that only abroad you have an equal legal position, but that within the state that you live in, this is not true. Then you are less than equal. Sadly, this has to be taught because it is true. For this, we'll have to look at the Charter of the Kingdom of the Netherlands. This is the highest legal document within the Kingdom of the Netherlands. It is the Charter of the Kingdom of the Netherlands that codifies the relation between the Netherlands, Aruba, Curaçao, and Sint Maarten. Entire courses are taught about this relation and about the Charter, but today I will focus on human rights law. The Charter defines that the countries take care of the realization of human rights. However, it is the Kingdom of the Netherlands as a whole that has to guarantee these human rights and is thus ultimately responsible. The Kingdom of the Netherlands can therefore interfere in the matters of the countries. Interestingly, the Kingdom can only interfere in the countries' matters of Aruba, Curaçao, and Sint Maarten, and not in the Netherlands. This makes sense if you look at what the Kingdom of the Netherlands is. Or, I should say, it makes sense if you look at the institutions of the Kingdom of the Netherlands that have the legal power to interfere in those local matters. These are the government of the kingdom and the legislator of the kingdom. The government consists of the king, all the Dutch ministers, and a minister plenipotentiary for each of the Caribbean countries, namely Aruba, Curaçao, and Sint Maarten. The king and the Dutch ministers are always involved in decision-making by the kingdom government, and the ministers plenipotentiary only when the subject at hand touches their own countries. It must then be clear that it is actually the Dutch government that is the kingdom government, and that is only supplemented with a minister plenipotentiary, which is a representative of the Caribbean government. And however you want to call this, there is an undeniable predominance of the Dutch ministers compared to the Caribbean partners. And it is this body, this kingdom government, that can interfere in Aruba and Curacao and Sint Maarten matters when it comes to human rights. Then there is also the kingdom legislature, and this consists of that same kingdom government and Dutch parliament. Members of the Caribbean parliaments do not have a vote at all when it comes to legislation at kingdom level. So there's an undeniable lack of democracy when it comes to interference by the kingdom in matters of Aruba, Curacao and Sint Maarten. So to recap, it is these bodies that can be seen as Dutch bodies with a bare minimum of involvement of the Caribbean partners that can decide on human rights in the Caribbean. And even though these bodies have the legal power to interfere in Caribbean matters, the Charter does not define what human rights are. It just mentions human rights. Human rights norms can only be found in the constitutions of Aruba, Curacao, Sint Maarten and the Netherlands. So all the 4 countries have their own legal document with human rights norms that are further interpreted by their own legislators, their own courts, their own, not their own legal scholars, but legal scholars in general. And of course under the influence of international human rights norms. However, it is only in the Caribbean that the kingdom can interfere when it comes to human rights norms. My conclusion then is that ultimately it is the kingdom that decides what human rights are, or at least how they should be interpreted in the Caribbean. And as we have seen, there's a real problem when it comes to democratic representation at the kingdom level, where kingdom bodies can undermine the bodies in the Caribbean. And it is these inequalities that make it possible that Caribbean pupils are taught that they are less than equal within the Kingdom of the Netherlands. I call it institutionalized racism because these inequalities are institutionalized through codification in law and then further interpretation by the legislator, courts, etc. And also these inequalities did not appear out of a vacuum, but find their root in Dutch colonialism. And as we know, European colonialism was justified by racism. Because of the inequalities, it is possible that most Dutch students don't really have to be aware of these legal relations to the Caribbean. And because it simply doesn't touch their lived reality, or at least not directly. And whereas Caribbean students are touched by the inequalities in a very obvious manner. So to return to human rights education, I conclude that human rights education in the Netherlands and in the Caribbean, so at both sides of the ocean, must include human rights in the kingdom at large, and not only human rights in one country. So students at both sides of the ocean should be made aware of the existing inequalities, for else these inequalities continue to be normalized. It is only when one is aware of these inequalities that one can take steps towards equality. And I want to end with 2 remarks. There's currently a bill that includes a general article in the Dutch constitution. And the article defines that the democratic rechtsstaat and human rights should be upheld. And I asked the question, what democratic rechtsstaat and what human rights? Because the Kingdom of the Netherlands is not a democratic rechtsstaat if we look at the lack of democracy in the Caribbean part of the Kingdom of the Netherlands. And also there is this ambiguous position of human rights within the Kingdom of the Netherlands at large. Then second, as a result of Dutch and worldwide protests against racism, Dutch government has officially committed itself to increased efforts against racism, and one of these efforts was the installation of a national coordinator against discrimination and racism. And these efforts have to include the matter of the inequalities between the Netherlands and Europe and the Caribbean islands that are part of the Kingdom of the Netherlands, because else those efforts, I think, will be incomplete. And I wanted to mention these two topics because human rights education does not only happen in classrooms. If we look at the United Nations and their understanding of what human rights education is, then actions by state officials also are part of human rights education. I want to leave it at that and then further discuss in the Q&A.
Thank you very much. Thank you, Lisanne, for a very interesting presentation. As a geographer, I was also very triggered by this territorial thinking and how much the colonial legacy is still implemented in human rights. I want to ask Alexandra to join us. And we have some time left for some discussion. Several challenges have been identified by you. Alexandra, you talked about the backlash, but also about a very big challenge, which is the conceptual challenge. Maybe start with that. Maybe we can talk a little bit more about how, especially intersectionality, how that can be translated into human rights law. I remember when we had the first webinar on discrimination at the labor market, we had the director of Article 1, Bernice, who mentioned that intersectionality in theory is a great concept and everybody is in favor of it, but then when it comes to implementation, when, for example, a case needs to be registered, we're kind of forced into a system where you need to tick one box. And it's very complicated to work with a concept like that. Do you have any reflections on that? Because I kind of hear similar lines of reasoning in your talk.
Yes, I would agree with that. The system again forces us to choose basically a single ground. But I think one way, because also, I mean, perhaps we want courts to start talking about intersectionality. But really, I mean, okay, then they might use the term. If that's the case, that's already sort of cause to hang the flag out for discrimination lawyers, at least this little group, I admit, but okay.
Step by step.
But that's not all you want, right? Because what the risk I see is that even when the term is used, it's again a very individualistic assessment of, okay, this Muslim woman, and that's not what the concept came from. We wanted to look more structurally at sexism and racism. Well, concretely, for example, the European Court of Human Rights, I think one, which hasn't talked so much explicitly yet about intersectionality, but one way of going at it is, I think, through this concept of stereotypes, which are often intersectional. So there was a case, for example, but again, it was very individualistic. It was a woman who had a medical, an operation that went wrong. She received damages for the fact that it went wrong, and then the courts lowered the amount of damages because they said, yeah, she's old and at an age where sex isn't so important anymore, and her children are already out of the house, so she only has to take care of her husband. And then she received lower damages. And there the European Court of Human Rights said, no, these are assumptions based on sex and age, stereotypical assumptions that deny women their sexuality. Now, I think that holds some potential, even though it was a very individualistic case. But through this concept of stereotypes, you can at least try to get there more at the intersectionality. But I don't have many good examples to share, I'm afraid. So I mostly share the skepticism of the speaker you already mentioned.
Yeah, I did find a example in Curacao at the Court of First Instance. There was a case about same-sex marriages, and in Curacao it's still not possible to marry someone of the same sex. But it is possible to do so in the Netherlands. And what the court said there is that, yes, it is possible for people in Curacao to travel to the Netherlands, marry in the Netherlands, and then come back and have that marriage being recognized. This is possible, but the court recognized also that this disproportionately affects people of a lower income, lower class, because for them it's more difficult to travel and marry and then have their relationship registered in that way. So that for the court was an argument to say that this legal situation cannot be upheld anymore, and that there is unjustifiable discrimination on the basis of sexual orientation. So I found it very remarkable that the court did take that into account, and I think also in a more structural way, because they did not zoom into one person, but really took into account this more general situation where people have to travel or not, and how this affects different groups. So there you have the intersectionality of sexual orientation and class. I found that very interesting, also because they did not mention at all the concept of intersectionality, but they did use it. So I'm curious if they are aware of how this relates to the idea of intersectionality as has been brought to the fore by activists and also scholars.
Interesting.
But that was one case that I found. So I think we still have some steps to take.
Yes, and another challenge I took from your talk is also the democratic representation in law. Do you have anything to say about opportunities for change or for improvement here? How can it be improved?
Well, democracy. That's the shortest answer. In what way, I'm not really sure, but what I am very aware of is that, as I said, people in the Caribbean are very aware of the fact that there is this lack of democracy. Scholars that that have an expertise in what we call kingdom law call this in a chic way democratic deficit. So those people all know that that there is this lack of democracy, and as I said, I think that a lot of people in the Netherlands are not aware of this lack of democracy. So I think that one very necessary step is making people aware of this, because I think that many Dutch people living in the Netherlands who do not have a relation with the Caribbean are not aware of this lack of democracy. So I mean, I think it will be very controversial for a lot of people, for me saying that the Netherlands is not a democratic rechtsstaat. And I don't think that a lot of people would then think about the Caribbean. So awareness, I think, would be very important. Also because the imbalances of power within the Kingdom of the Netherlands makes it that people in the Caribbean do not really have the legal power, I would say, to change the situation in their own. We really need also the Dutch legislator for this. So also the Dutch voters.
And Alexandra, you teach law here at Utrecht University. Is it part of our curriculum?
I'm not sure, because I don't teach constitutional law. I was taught that when I was a student at Leiden years ago. Can't vouch for my colleagues.
Great. Yeah, well, I taught at 3 different universities, and they all lack knowledge on
lack knowledge. So there is still a lot to improve.
I think so.
Yes. And are there any other challenges that we did not touch upon but are really important to mention here? Also
looking at each other.
Listening to each other, were there other things, or did the presentations trigger your mind in the sense that you want to respond to each other?
Well, I looked a lot at race when looking at the United Nations, and I find that the CERT, which is the Committee for the Race Convention, is very how do you say that? Transformative, maybe. But they do not use this idea of transformative equality. So I think that it would be nice for the committees to, you know, find each other and have discussions about the concepts that they use. Also because I think that the CERT also has mechanisms that can really contribute to equality. So I think that they can learn from each other. Also, when it comes to interpretation of human rights norms, I find it wonderful that the CERT really tries to include as much perspectives as possible. So when creating general recommendations, for example, they make a concept and make it available online, and people can react. So any person can react, and they take that into account. So these are things that didn't happen 10 years ago, and not at all decades ago.
Yeah,
so
approach.
Exactly, and I think that those are steps that are necessary and good. So yeah, those are things that they can learn from each other. So yeah, that would be good. I think so.
Yeah, I'd agree with that. And I see that compartmentalization also in the scholarship. So you have people who do, you know, gender equality, and then sexual orientation or LGBTIQ rights is a whole other world. And you think, okay, there's a lot intersectionality also. But, so there's a lot of compartmentalization also on the grounds, but also between the different bodies and knowledge of the different bodies. Not all EU scholars know a lot about the European Convention on Human Rights, let alone, you know, the Inter-American system or the African system. So through comparative research, but also through more interaction between, I agree with that, the treaty bodies and different experts, there's probably a world to gain.
Interdisciplinarity as well.
Yeah. Well, that's...
And different bodies and different agencies.
No, this is just amongst lawyers.
Yes.
The
widening and the deepening.
Yes, we're widening further. There is indeed a world to gain insights from each other, I think.
Wonderful. Okay, I want to thank the speakers, and I have a little present for you. And you're not allowed to open it because it's the secret of the series. Okay. All the speakers get the same present, and during the final webinar we will reveal what the present is to our audience.
Looking forward to it.
Yes, so I also want to stress to the audience that if you want to contact us, if you want to keep informed, please email us at migration@uu.nl. We also have a newsletter you can sign up for, so then you are informed about all the activities that we are organizing. And I want to close with announcing the next webinar, which will be the final webinar in our series, which will deal with racism and discrimination in our own institution. So we will talk about the university. On Friday the 10th of June, we will speak with Jamila Maskat from Gender Studies and Louise Otar, winner of the UU Diversity Award, about the topic of racism and discrimination in our university. And for this webinar, we recommend you to watch a short film beforehand. And the film is called Somalinimo. And it features British Somali students from Cambridge University. And the film discusses why these students often feel out of place in the university as a white space. So you can find the link to the movie on our website, and we will take the movie as a starting point for a discussion in the final webinar. So we hope to see you there, and we're looking forward to see you next time. Thank you.